You know, in the wake of this New York Times reporting about how the political considerations that the Supreme Court made in hiding the case from the docket and otherwise making, you know, decisions that seemed very clearly political, very clearly partisan in taking up the Dobbs case, it really makes you question the very notion of their strict constitutionalism and whether or not that has long ago been trumped by partisan affiliation. I wonder how you think it all shakes out if and when the Supreme Court takes it up.
I beg to differ just a little bit, because there is nothing in the Constitution of the United States that from which you could imply a right to an abortion. The only basis for maintaining Roe was stare decisis, and I think I would have done that because the decision was 50 years old. But there was no textual basis, no historical basis for the right to an abortion. Nonetheless, here it's quite different. The language is unmistakably clear, and as Mark says, and we don't agree on a lot many times, but Mark says here that there's really no legal basis to ignore Section 3 of the 14th Amendment. And in fact, in the Supreme Court, emblazoned in the marble, is a saying, an old Latin saying, and forgive my inadequate high school Latin pronunciation, but it goes like, I think it's fiat justitia ruat caelum, and it means let justice reign, though the heavens may fall. In other words, you have to let the chips fall where it may. If the legal conclusion is indisputable, which I think it is here, and there was no contention by the dissent here that the legal conclusion was wrong, or no contention here that the facts were not shown by clear and convincing proof in the district court, I don't know how they get around it. And I wrote an article today in the Atlantic saying exactly that. The dissent's weakness last night showed that the majority opinion was quite correct.
Yeah, and I'm not going to relitigate the Dobbs decision with you because we don't have time for it, George. But
well, I think we could do that for a week.
Yeah, we'll do that on another segment. The point I'm trying to make is that this court is not immune from political considerations. I mean, the very way in which they hid the Dobbs decision on the docket suggests that they understood the political ramifications of that. But to your point, Mark, this court has proposed that it is not a political body, that it doesn't take political policy considerations. It's just looking at the Constitution. The state Supreme Court ruling goes back and quotes Neil Gorsuch in this ruling. It's specifically targeting a decision that Neil Gorsuch made, a ruling he made in 2012 as an appellate court judge in Colorado, where he recognized it is in a state's legitimate interest to protect the integrity and practical functioning of the political process that permits the state to exclude from the ballot candidates who are constitutionally prohibited from assuming office. In addition to being strict constitutionalists, these justices tend to love to send things back to the states and tend to really be proponents of states' rights.
Right. I mean, we heard this after the 2016 election, right? When people complained that Donald Trump had lost the popular vote, the conservative response was, well, we're a republic, not a democracy. Really, the states are in the driver's seat when it comes to federal elections. And that really should cut both ways for Republicans in 2024, because if the states are in the driver's seat, if they're the ones making these decisions, I don't see why a state shouldn't be able to apply the 14th Amendment as written and say, you know what, there aren't very many qualifications to be president, right? You have to be 35, you have to be a natural born citizen. You can't have engaged in an insurrection. And I think it's quite reasonable, given our federalist system, for a state to have the authority through its Supreme Court to say, you know, we're just not going to let this guy on the ballot because he lacks one of the very few constitutional qualifications to run. I want to add one point to what George said, though. You know, I think we should look at this through the lens of politics. Politics can be a consideration. I also think we need to consider whether these justices can or should look at outcomes of a case, right? So, you know, when the court decided a big Second Amendment decision last year, where the court declared that most restrictions on firearms are presumptively unconstitutional, there was a lot of hue and cry on the other side that this would lead to more gun deaths, that this would imperil American citizens. And the conservative majority's response was a big shrug. You know, they basically said, that's not our problem. Our only job is to decide what this means. And the chips will fall where they may. Any kind of consideration of the results or the outcomes, that would be a kind of biased judging that has no place in our judiciary. Well, if that's true of guns and true of so many other things, corporations buying elections, women having bodily autonomy, it should obviously be true of Trump's qualification to be president as well. And so I think this will be a moment of truth, not just for the originalists in terms of their principle of how to apply the Constitution, but how they should be judges, how they should exercise the authority, the extraordinary authority that they have been given to have the final word on the law. Do they balk and chicken out and say this is just too radical for us? Or do they acknowledge that the 14th Amendment was kind of radical, it still is, and applying it as written might lead to some kind of fearful results, but that's the court's job, and it's our job to respond.